Hi, friends. Welcome to Lawyers Info Hub. It's a pleasure to always create content on this platform. If you're a returning subscriber, I really appreciate you. If you're coming to our channel for the first time, you're welcome and do consider subscribing to our channel. We have wonderful videos on the channel that is of great help to you, that will help you improve your practice, that will help you become a better law student. Peradventure, you're a law student, to help you generally in advancing your law career. So today we're looking at the defenses and bars to a petition for divorce. Defenses and bars to a petition for divorce. What are those things that a respondent can present to the court to make the court refuse to grant order for dissolution of marriage? Ordinarily, a petitioner who has proved to the satisfaction of the court that the marriage has broken irretrievably is entitled to a decree of dissolution of marriage. But such a decree may be refused if there is an absolute or discretionary bar which exists to the case. Now, there are three absolute bars to a petition for divorce. The first one is condonation, the second one is connivance, and the third one is collusion. We also have the discretionary bars, but we are focusing on the absolute bars, which are the three things I've mentioned. Now, the first one is condonation. What do you imply or mean by condonation? Condonation implies the forgiveness of a spouse who has committed a matrimonial misconduct and the reinstatement of that spouse to the position he or she was, which is the position of a spouse. So in condonation, we have two constitutive elements, which are the forgiveness and the reinstatement. Now, these two elements must be present, must be seen before you can say there is condonation. Now, it is important that a spouse who condones must be substantially aware of the matrimonial misconduct committed. Someone cannot say, I have forgiven you, when the person does not even know what the misconduct is all about. Now, forgiveness alone without reinstatement cannot constitute condonation. So the spouse who is guilty of the matrimonial misconduct must be reinstated to the position of a spouse. Now, reinstatement cannot occur unless reconciliation takes place between the parties. Now, reinstatement usually takes the form of continuation or resumption of cohabitation. Now, that cohabitation must be accompanied by mutual intention to live together as husband and wife. So that is what condonation in summary is all about. And these two elements must be present. Now, it's important to know that unless where the respondent is at the time of the petition is of a sound mind and unlikely to recover therefrom, condonation applies to all types of conduct constituting the facts on which the petition constitution is all about. So the petitioner should be able to prove this condonation to the satisfaction of the court. Now, it's also important to note that under connivance, when you talk about connivance, you're talking about a situation where a petitioner consented, encouraged, or willfully contributed to the commission of the misconduct on which the petition is based. The respondent is telling the court, the petitioner who has brought this petition consented, encouraged, and willfully contributed to the commission of the misconduct on which this petition for dissolution of marriage is predicated upon. Now, this connivance as a bar or defense operates on the principle of voluntary non-fit injuria. Therefore, a spouse will not therefore be obtain a relief in the misconduct in which he or she encouraged. So, connivance may also take the form of express consent to the misconduct, where there's express consent. That is why in matrimonial proceedings, you see, during examination in chief, questions as to connivance is asked. Whether the petitioner, did you connive? Is there any form of connivance between you and the respondent in bringing this petition? That question is very important because is a bar or a defense that can make the court refuse granting the order sought by the petitioner. Now, collusion, which is the third defense of bar, implies an agreement or acting in concert to cure the initiation of a suit tend to cause perversion of justice. For there to be collusion, there must be two elements, which is agreement and improper motive or purpose. Agreement and improper motive or purpose. The essence of collusion is that the petitioner and the respondent, in concert with the common intention to cause a perversion of what? Justice. There cannot be collusion without agreement. And collusion will arise if the agreement is between the parties. Now, agreement between parties to a divorce is treated as suspect because it often deprives the court of the freedom of eliciting the whole truth. So where the parties involved collided in bringing the petition, it constitutes a bar or a defense. There is collusion where a party is bribed or induced to initiate or prosecute divorce proceedings. Now, an agreement to obtain a divorce where normally the court will not grant a decree is collusive. So collusion therefore arises where a party by agreement commits or appears to commit a matrimonial misconduct, or where on agreement a true case is established by false evidence. So it's very important. That is why this question of collusion is also asked during examination in chief, so that the petitioner will be able to prove to the court that I did not collide with the respondent in bringing this divorce petition. It's also important to know that there will be collusion if, for money or for a promise of money, a party is induced not to defend or to suppress material facts. Sometimes you see there are instances where a wife, for example, is induced to present a petition on the promise of a substantial sum of money compensation. Then you can say there is what? Collusion. So these three things constitute as a bar, the absolute bars defense to a petition for divorce. We also have the discretionary bars, which we'll discuss in another video. So these three things, if a respondent can prove it to the court that there is, collusion, connivance, and condonation, then the court may not grant the decree for dissolution of marriage sought by the petition. If you have any question, please do drop it on the comment section. If you have anything to add, you can also drop it on the comment section. We believe that this quick summary gives you an idea of what the absolute bar or defense to petition looks like and what it's all about. I just hope you learned something today. We have several videos on the channel that is very helpful, and I know that by the time you go through them, you will enjoy them. Do take care of yourself and know that you can always be the best. Do take care.